At 10 p.m. Eastern, Monday through Friday, Banfield goes on the air. Whether my hair is done or not, whether I am ready or not, whether I've researched it, written, I got to be on the air. So I know a thing or two about deadlines, and lawyers do too, especially trial lawyers. Tonight, Ann Taylor, lead attorney for accused quadruple murderer Bryan Kohberger, is up against a doozy. For now, at least, she is expected to stand up and deliver her opening statements 53 days from today on August the 11th. Before that, however, she has to at least have a working knowledge of 68 terabytes of evidence. And if you're wondering what 68 terabytes is, it is the equivalent of the entire Wikipedia website times 70. Think about it. For weeks now, she has been fighting to get the trial delayed and warning that if the trial's not delayed, she won't be able to give her client, quote, effective assistance of counsel. Remember those words. She says his constitutional rights will be violated as a result. The judge has yet to formally rule on her request to delay the start, but yesterday hinted strongly that all sides should be ready to go as planned on August 11th. And Taylor is hardly the first attorney to feel rushed and under the gun in a big case. Prosecutors face the exact same pressures as the defense attorneys do, and to be fair, I don't know, Team Kohberger may also just be trying to stall. But either way, John Picerno can relate. Years ago, as a public defender in Kansas City, he was assigned a 16-count rape and kidnapping case with minimal time to get up to speed. And so, Mr. Picerno refused to go to trial, saying that he was unprepared and he dug in his heels. And so the judge in the case responded by throwing him in jail. Threw him in jail for contempt. And he spent 4 days locked up over Father's Day weekend, too. And when Mr. Picerno got out, the public defender's office fired him. John Picerno is live with me now. Wow, couldn't be a better timed guest to talk to you about what Ann Taylor is going through. When you heard about Ann Taylor yesterday, is that why you immediately wrote to me and said, I've been there, done that?
Yes, in part. I mean, I think you hit the nail on the head that most trial attorneys find themselves in this situation. But hers is a really extreme situation. Just for everyone to understand how much 64 terabytes is, routinely on federal cases involving drug cases where we get 20 or 30 defendants all charged at the same time, usually it involves a huge amount of surveillance of telephone cameras, telephone recordings, text messages, emails, anything on their social media that's on their phones. And we normally will get a drive that has anywhere from 1, 2, or 3, or 4 terabytes. And of course, that's for all the defendants. And it's just a huge task to go through. She has 64 terabytes with just one defendant. I would say it's virtually humanly impossible for her to get through all of that material one time, never mind, being prepared for trial on it.
I gave the example of Wikipedia, the entire site times 70. I'm going to give another couple of examples here. 68 million photos, 24,000 full-length high-def movies, 13.6 million songs, and 136 million documents. That's what 68 terabytes amounts to. John, is this kind of the way it is now in the digital world? There's just, I don't even want to look at my photos because I don't delete them enough. And so there are thousands and thousands. Is that just the way it is now for lawyers? You're going to be given these massive Everest-style mountains of discovery, and you're going to have to do it, in a short period of time.
It really is, Ashleigh. That's the one biggest change, I think, in my practice over the decades has been that we get everything that electronically now, and there's so much of it. Fortunately, like the example I used a moment ago, we're able to weed through it and get down to our specific defendant. But when there's so much information that she has to look through, how does she know what's important and what isn't important until she has the opportunity to review it?
So did you know that the possibility would be contempt and jail? And I guess the extension of that question is, does Ann know that as well?
Oh, I'm confident that a lawyer for quality knows that. I was a young public defender. I'd been a public defender for less than a couple of years. I knew that that was a possibility. I wasn't certain that that was going to be the end result when I did what I chose to do. But, my main goal there was to delay the trial for my client. Ultimately, I was successful in doing that. He did not go to trial as scheduled. Another lawyer was appointed for him, and some months later, he had his trial. But it's always in the back of your mind.
Thank you for watching. Subscribe below and download our NewsNation app right now on your phone, and you will get fact-based, unbiased news for all Americans.